The Children, Guardianship and Custody Act, Section 7. The court may make order as to custody. Subsection 1 of Section 7. The court may, upon the application of the father or mother of a child, make such order as it may think fit regarding the custody of such child and the right of access thereto of either parent, having regard to the welfare of the child and to the conduct of the parents and to the wishes as well of the mother as of the father, and may alter, vary, or discharge such order on the application of either parent or after the death of either parent of any guardian under this act, and in every case may make such order respecting costs as it may think just. Section 7, subsection 2. The power of the court under subsection 1 to make an order as to the custody of a child and the right of access thereto may be exercised notwithstanding that the mother of the child is then residing with the father of the child. So this is saying even if they both parents live together, the court still has power to make an order of custody. All right. Subsection 3 of Section 7, where the court under subsection 1 makes an order giving the custody of the child to the mother, then whether or not the mother is residing with the father, the court may further order that the father shall pay to the mother towards the maintenance of the child such weekly or other periodical sum as the court, having regard to the means of the father, may think reasonable. So this is saying that even if both parents live together, they may still, if the mother has custody, they may still order child maintenance to be paid to the mother. Subsection 4. No such order, whether for custody or maintenance, shall be enforceable, and no liability thereunder shall occur while the mother resides with the father. And any such order shall cease to have effect if, for a period of 3 months after it is made, the mother of the child continues to reside with the father. So if both parents live together and the court makes an order, it is valid for only 3 months once they are living together. If they make an order for child support, it says here, no such order, whether for custody or maintenance, shall be enforceable if they live together. Alright, they may make an order, but I guess the police would not be able to take action to arrest anyone if that order is violated, if both parents live together. Alright. Subsection 5 of Section 7. Any order so made may, on the application either of the father or mother of the child, be varied or discharged by a subsequent order. Section 7a. Order may extend payments after age attained. Any order made under subsection 3 of Section 7 may provide, in addition, to the matter specified in that subsection A, that the sum ordered to be paid thereunder shall continue to be paid for any period after the child to whom the order relates attains the age of 18 years, but not extending beyond the date on which he attains the age of 21 years. So the court can order maintenance, child maintenance, up to 21 years old. Alright? B, that the sum shall, after the child to whom the order relates attains the age of 18 years, be paid to him instead of the person to whom it was previously paid. Okay. So, here, they seem to be saying that if child maintenance was being paid to a parent, once that child becomes 18 years old, then the parent who is paying the child maintenance can pay the child, the money instead of the other parent. Okay. 7b. Court may order maintenance payments in cases where order previously in force. Alright. Subsection 1. Subject to subsection 2, where a person who has attained the age of 18 years but has not attained the age of 21 years had, while he was a minor, been the subject of an order under any of the provisions of this Act, the court may, on the application of either parent of that person or on the application of that person himself, make an order requiring either parent to pay to the other parent or to the said person for any period not extending beyond the date on which that person attained the age of 21 years. Oh, so here it says that person had been a minor, that's below 18, right? The court may, on the application of either parent of that person or that person himself or herself, may apply that the maintenance order be paid to the other parent or to the person, the said person. So it could continue going to the other parent or to the child. When I say child, I mean the offspring of the parents, even though technically is no longer a child once it passes the age of 18. Alright. But it cannot extend beyond 21 years. Such sums towards his maintenance as having regard to the means of the person ordered to make the payment, the court thinks reasonable. Subsection 2. No order shall be made under this section. No order previously made shall be enforceable, and no liability thereunder shall occur while the parents are residing together, and such order shall cease to have effect if, for a period of 3 months continuously after it was made, the parents continue to reside together. So basically, child maintenance order is not enforceable if both parents live together, and that order would expire after 3 months if the parents continue to live together. Alright. Section 8, subsection 1. Section 8, power of court to remove guardian. the court may, in its discretion, on being satisfied that it is for the welfare of the child, remove from his office any testamentary guardian or any guardian appointed or acting by virtue of this act, and may also, if the court shall deem it to be for the welfare of the child, appoint another guardian in place of the guardian so removed. So the court can actually remove a guardian and appoint another guardian. Subsection 2. In this section, the expression court means the Supreme Court. Alright? Section 9. Disputes between joint guardians. Where two or more persons act as joint guardians of a child and they are unable to agree on any question affecting the welfare of the child, any of them may apply to the court for its direction, and the court may make such order regarding the matters in difference as it may think proper. Section 10 was repealed by Act 11 of 1991. Section 11. In case of separation, deed between father and mother. No agreement contained in any separation deed made between the father and the mother of a child shall be held to be invalid by reason only of its providing that the father of such child shall give up custody or control thereof by the mother. So let me see this again. No agreement contained in any separation deed made between the father and mother shall be held to be invalid by reason only of its providing that the father of such child shall give up custody. So it's saying even if the father give up custody, that itself would not make a separation deed invalid. Provided always that the court shall not enforce any such agreement if it is of the opinion that it will not be for the benefit of the child to give effect thereto. Power of court as to production of child. Where the parent of a child applies to the court for a writ or order for the protection of the child, and the court is of opinion that the parent has abandoned or deserted the child, or that he has otherwise so conducted himself that the court should refuse to enforce his right to the custody of the child, the court may in its discretion decline to issue the writ or make the order. Alright? Section 13. Power of court to order payments of costs of bringing up child. If at the time of the application for a writ or order for the production of the child is being brought up by another person, the court may in its discretion, or if it orders the child to be given up to the parent, further order that the parent shall pay to such person the whole of the cost properly incurred in bringing up the child, or such portion thereof as shall seem to the court to be just and reasonable, having regard to the circumstances of the case. Alright? So if somebody else is bringing up the child, the court may, if it orders the parent of the child to be given up to the parent, if it orders the child to be given up to the parent, further order that the parent shall pay to such person the whole of the cost of properly incurred. So if somebody else was bringing up the child, if at the time of appointment for a writ or order for the protection of the child is being brought up by another person, okay, the court may order the parent to pay that person for bringing up the child. Alright? Section 14. We'll look at section 14 in another video.